Additional witnesses, people rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right. Do you have a motion?
Yes, Your Honor. At this time, people move for bind over on the single count of assaulting, resisting, or obstructing Darnell Tyson. Will reserve any further argument for rebuttal.
Respond. The sergeant's name was Sergeant Griggs, wasn't it?
Gibbs,
Gibbs.
Gibb, opens boy S.
Yeah,
Why are we not hearing the testimony of the other witnesses?
I'm sorry?
I was asking why we're not hearing the testimony of the other witnesses.
Because neither one of the parties called them.
I would like to call them, Your Honor.
Any objection to reopening the proofs?
Your Honor, I will let the court know part of the reason I changed my mind is because I failed to instruct the officers who were in the hallway that they could not watch the proceedings on YouTube. So it was my understanding they did watch the testimony of Officer Tyson on YouTube, and I apologize for that. Didn't intend to have that happen. I deeply am regretful of that. I did not know what was going on until I went out in the hallway. Didn't intend to call them because their sequestration had been broken and rest on the proofs that were proof for the court.
Still wish to call them?
Yeah.
Yes?
Yes, I do, Your Honor.
Are they still here?
I believe so. Which one?
Which one do you want, sir?
Both of them.
Both of them. Great. Just bring everybody back.
All right. Sounds great.
Okay. So, which one do you want to call, Mr. Magoo?
Start with Officer Smith.
Buckle up, guys. Today we are watching a courtroom case where the defendant is representing himself, and things get unusual fast. The hearing is about to close when the judge drops a bombshell. He reveals that officers waiting in the hallway watched the prior testimony live on YouTube, breaking sequestration. The judge openly apologizes, admits he failed to instruct them, and says he deeply regrets it. Despite this, the defense still wants to call those witnesses. The room shifts completely. What started as a wrap-up becomes a reopening of proof.
All right. Officer Smith, did you want the other officer? Did you want the sergeant? Did you want the sergeant sequestered during this testimony? Or
Yes. No, you.
no, you don't give orders. You just don't.
Sorry.
You just don't. No, you don't.
It was a request.
No, it doesn't matter. Yeah, keep smiling. That won't end well. Let's have him so.
Raise your right hand. You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth. Okay, sir. See, state your first and last name for the record, please.
First name is Lawrence, LAWRENCE, last name is Smith, S-M-I-T-H.
You may inquire.
Oh, they don't start at all because they don't want.
It's your witness.
Right. How you doing, Officer Smith? Okay. You have to lay a foundation with since we all know where we're at on the night. Where were you in the October 11th, 2:50 in the morning, and what brought you to there?
Objection compound.
Okay.
Sustained. Ask your question.
What led you to a parking lot in Ypsilanti on October 11th, 2024 at 2:50 in the morning, approximately?
We were dispatched to the fight progress.
Fight in progress.
Yes.
Did you get a description of the people in the fight?
confirmatory subpoena.
What was the description? Do you remember? You were just looking for 2 people, or how many people? Don't recall. Okay. Do you recall the ethnicity of the people that were called? Were they what the dispatch? Who was the dispatched over the fight? I believe they gave some descriptive words in the police report. And do you recall what the do you recall any descriptive words that would characterize the people that you were looking for on October 11th? What led you to approach me?
Well, we've seen an individual sitting, I would be slumped over and looking non-responsive at the point, and we've seen alcoholic beverages around the individual, so we assumed that it was high intox. So at that point, it's our job and duty to end up rendering aid to the individual, and then having the ambulance come and assess their medical needs at that point.
Okay. You assessed that another individual was highly intoxicated?
Yes, due to our observations and then our directing by our sergeant.
Is that a crime? Highly intoxicated?
Objection, Your Honor. Relevant.
Sustained.
Which part of assuming somebody was highly intoxicated warrants your interjection?
Can you ask your question again, just for clarification?
Are you trained on high intox?
I'm not trained on high intox.
On recognizing drunk drivers or something?
I've been in the police for less than a year, and I've observed multiple people that have high intox, and then also by directing my sergeant, who's also been doing this for 4 years plus. I believe that we can observe somebody that's high intox. So that
He was definitely highly intox, huh? You would guarantee, right?
Objection, Your Honor. That misstates the testimony evidence.
You can keep trying.
Okay.
The form of your questions are a problem.
Okay. At what point did you and I engage physically?
when you didn't follow the directives of my sergeant, who was let you leave the scene as we render aid to your friend and assess what he has.
Did he cite any legal authority to make me leave the scene?
Objection, Your Honor. Relevance.
Sustained.
Relevance. John, I'm trying to understand the amount. Do you know? Okay, never mind. How long were you on the scene, approximately, until I was arrested?
Look at the report to refresh my memory.
Okay. Under 5 minutes?
I do not recall at the moment. I have to look at my report to refresh my memory.
Okay. Did you or your sergeant establish or discuss any probable cause to arrest me?
My sergeant gave us a directive to put you in the back of the patrol vehicle due to obstructing our investigation. We were trying to assist your friend in getting medical attention. At that point, you were resisting. You put your hands onto the car, not the patrol vehicle, the car, and you clenched your palms together.
So, but hold up.
Officer Smith takes the stand and the defendant begins questioning him directly. The exchange is raw and unfiltered. The defendant asks whether being intoxicated is a crime, pushing the officer on why they approached his friend at all. Smith explains they saw someone slumped over with alcohol nearby and called for medical help. Then things escalate. The officer begins describing how the defendant resisted, put his hands on the car, and had to be forcibly detained. The defendant tries to cut him off mid-answer, and the judge shuts it down immediately, ordering him to let the witness finish.
Hold up a second.
No, you cannot stop him. You ask the question, he's gonna get to answer it. So you don't stop him. Go ahead.
Sir.
Go ahead. Yes, you may.
So at that point, you were resisting. So then we got the direct officer to detain you. Then after you saw my partner, Sergeant gives another directive to place you in the back of the patrol vehicle for assault on a police officer. So I had multiple encounters with you putting your hands on. Yes.
Okay. Backing up to the point of which I was thrown up against the vehicle. You're saying that the crime or the violation that I was in was not stepping away. Is that correct?
You were obstructing the investigation, yes.
Is obstruction, is that a physical act?
I'm going to object this to a legal conclusion.
Sustained.
Is obstruction of justice, is that a verbal or a physical?
Sir. What are you asking? Because it seems to me that you seem to be asking this officer for a legal conclusion. And
Okay.
I'm not going to have him answer the question until you can clarify what your question is.
In your opinion, is it your opinion that I obstructed physically?
I'm going to object this to the form of the question as to the time, because it's not clear to me.
Sustained. I'll sustain it. You need to clarify your question as to at what point.
Yeah, at the point of which Officer Gibbs or Sergeant Gibbs and yourself pushed me against the vehicle to arrest me. To detain. Okay. At that time, was my detainment because of verbal or physical obstruction?
My sergeant asked you to place your hands on your back. You did not do so. So we assist you by placing your hands on your back. You did not do so when you was placed against the vehicle.
So could you label where my obstruction was?
Your objection. Ask the answer. I think he's been extremely clear about the different ways in which the defendant obstructed the investigation.
What investigation is what I'm trying to get to? We still don't have a corpus delicti, Your Honor.
Oh, I think we do, but that's okay. You think differently. I'll sustain the objection. You can try again, rephrase your question.
Under what investigation were you under?
Assisting your friend who was high intox.
Assisting high intox. Okay. Is that a normal police duty?
Yes.
Okay. Under those situations, is there ever a charge that would complement this?
What?
Complement the assisting the high intox.
Okay, let's try to get this clear. You were there rendering medical assistance, potential medical assistance to the individual that was sitting on the ground,
Yes,
right? Part of a police officer's duties, if they see someone that is in distress or in need of medical attention, would be to render aid. Is that correct?
Yes.
And that's what you were doing that evening?
Yes, sir.
Okay, now we can move on.
Okay. What do you think my role was?
Your role in what can you clarify for me, sir?
So you have one really intoxicated friend and then one that's trying to talk to you. At which point or which role do you think I would be under when this investigation is going down?
I don't even know what that means. What do you mean role?
Your Honor, the officers showed up on the scene
Yes.
there was no call for them to be there for me or my buddy. Okay, they showed up and they made themselves a part of our taxi ride home, and I got a charge for it.
No. Here's what happened. As I says, I can best determine. They're dispatched regarding a fight. They come across something else. It was somebody that may look like they need medical attention. As this officers testified, that's part of their obligation to render aid when it looks as though it's necessary. They were attempting to try to do so. Your intervention or role began to take place when you failed to follow the instruction of Sergeant Gibbs. That's what I have so far. So now you may go on to your next question.
Did you write your police report for that night? You did?
Yes.
You do that manually, or I'm sorry, on a computer, or do you handwrite them? Did you happen to write anybody else's? The reports?
No.
No? Okay. Have you read the report recently?
Yes.
Have you read all of them?
Yes.
Do you find any similarities between them?
Objection, Your Honor. Relevance.
Good response to that?
Relevance there. I'm trying to figure out where these the relevance, they're all identical reports. It's pretty relevant. They were copied and pasted.
Maybe because they were all there.
And they all said exactly the same thing. Verbatim.
Okay. So this officer didn't write anybody else's reports. He just testified to that.
Okay.
So what's your next question to this officer?
Okay. On your report, do you recall any notaries of the presence of alcohol?
All I need to look at my report to the first one.
Okay. Do you recall reporting any alcohol?
I'll have to look at my report to the first one.
Okay. Would you agree that alcohol was a significant contribution to the reason why me and you met?
I'm going to object to speculation, Your Honor.
Sustained.
Okay, we have my friend that was called for high intox, correct?
No, we were dispatched to a fight in progress.
Okay. Fight in progress. You showed up on the scene and you notice someone's highly intoxicated. That wasn't a part of the fight that you were dispatched for, correct?
Objection leading.
Sustained.
Who dispatched Huron Valley Ambulance?
Oh, it's Tyson.
Officer Tyson did? Okay. What was the dispatch for?
I didn't tell us.
Okay. Seeing how that was, you agreed that that was part of your investigative duties to assist in my buddy's intoxication.
Well, I defer that question.
I know that. Okay.
So rephrase.
Let me rephrase. Would you agree that the reason that you and I met was because of alcohol?
Objection. Ask an answer.
Sustained.
What was the
Rephrase.
objection?
You heard the objection.
I didn't hear it. I'm sorry.
It was actually asked an answer, but it should have been relevance.
Yes, it could actually apply to both.
It does.
So,
Okay. Ask and answer. Is that what she said?
yes, rather clearly. It's about the fourth or fifth time that she's had to do that. So I
Okay.
would think 5. Thank you, Mr. Kennedy.
Did you find any alcohol on the scene?
You asked your question, just verification.
Did you find any alcohol when you guys arrived on the scene?
Observed any alcohol or fine?
Both. Yeah. Officer, you heard Officer Tyson's testimony?
Yes.
Okay. Did you hear him mention the fireball? Yes. Okay. And then you heard him mention the seltzers?
Yes.
Okay. Did you see these yourself on? You did. Okay. So was there anything else besides those two?
Nothing.
Okay. Nothing illegal? You don't recall any illegal contraband or anything on us or near us?
Your Honor, objection, I'm gonna object because he said he has this court to refresh the recollection, since he can't answer that question.
Sustained.
When you're collecting evidence as part of your duties, what is the proper protocol when you collect evidence?
Can you clarify your question? Ask it again, please.
What standards or procedures do you conduct when you are obtaining evidence on an investigation? Do you log that information? Do you report it to anybody?
I'm objecting to the compound.
Sustained.
The cross-examination gets tense as the defendant drills down on whether obstruction was verbal or physical. The judge repeatedly sustains objections and pushes the defendant to rephrase, warning him his questions are asking the officer for legal conclusions. The defendant then pivots to police reports, suggesting all 3 officers filed identical reports, hinting they were copied and pasted. The prosecution fires back that they were all present and witnessed the same thing. The session ends with the defendant asking a hypothetical about a knife to probe evidence procedures, and the officer delivers a surprisingly detailed and impressive answer that draws a rare compliment from the court.
He's not getting the,
I'm so sorry, Your Honor. It's okay.
Goodbye, Miss Senda. Enjoy your dinner. Take care.
if you found a knife nearby on the same, describe the same scenario, there was a switchblade knife, what would you do?
Objection, relevance.
I'm asking for the
I'll
procedures.
overrule it. Let him go.
Depending on the relevance of the knife to the situation or investigation, we'll dispose of the knife if it comes to not being relevant due to there being a safety hazard. If it was logged as evidence, it would be logged properly at the YPD station, the Ipswich police station.
Okay.
Before even touching the knife, I'll put on gloves. Then I'll put it into an evidence bag, label it, tag it, and I'll place it into my patrol vehicle. After that, I'll transfer it to the Ipswich police department, and I'll log it into the evidence locker, and I'll notify my sergeant immediately.
Okay.
Wow. No, go ahead. I'm sorry. That was an impressive answer.
So, given that you did observe alcohol on the scene, who reported it?
Who reported it? Like, reported to Metro Dispatch about the high intoxicated friend? Or what do we do with the?
I'm specifically asking about the the reports that were made, but also what happened with the items as well.
The reports of what?
The police reports, Your Honor.
What do you mean what happened to them?
Not what happened to him. What happened to the mention of alcohol in the police reports? Because there was none.
Okay.
Refraining a question, alcohol was found, and who reported it?
What do you,
I reported it to my sergeant, my scene.
Okay.
Was there present. I
Okay.
reported to Officer Tyson, because possibly they might be intoxicated as well.
Okay. Do you know what happened to the alcohol that was on the scene?
Not to my recollection. At the time.
Oh. Okay. Did you get a chance to review the body cam footage from that night?
I did.
And is it your opinion that that I obstructed a verbal command by Sergeant Gibbs?
No object to the conclusion, Your Honor.
I'll overrule it. I'll let him answer.
That's the question, yes, sir.
It was a verbal disagreement.
No, that wasn't your question.
Ask your question.
What was that?
Can you ask your question, please, sir?
It is your opinion that I verbally obstructed Sergeant Gibbs?
Well,
I believe that you instructed by not listening to his verbal commands. And then you were trying to render aid to your friend.
Do you recall his verbal commands? Does walk away sound familiar?
Yes, it is.
Okay.
My sergeant says that frequently, but speaking so.
Right. Right. Okay. With the walk away term, do you ever hear him cite any other like legal authority with it?
You're asking to that night, saying anything to it, or just in general?
Yeah, just in general for right now. I'm just trying to figure out if there's like it's like a rule or like a law that you might say with that would like get somebody kind of, you arrested me.
At that time, we see somebody that's obstruction to our investigation, we advise them to move along. If they do not move along, that's an undertaking.
How much time do they have for that?
It was corrected by our sergeant.
Okay.
I think 3 times at least. So go ahead.
Did I physically prevent you from doing your duties?
Me personally, no.
Did I threaten you?
Not to my recollection.
Did I touch you?
No.
If I ignored you and just walked away, say 5 feet, would that have satisfied you?
It was something like that.
Do you know of a distance that's safe for me to be in those situations?
It was directed by my sergeant at the desk.
Okay. Let's take away that situation now and just a normal situation where you're investigating something and maybe your sergeant's not there.
Okay.
Okay. Is there a certain distance that someone has to be?
Yeah, I'm gonna check Mr. Relevance. How about this?
And speculation,
Answer.
yes. Sustained. Rephrase your question.
You could tell me a safe distance that I would have been that day that would have satisfied you and your sergeant. I understand it was his command, but what is your opinion that would have been a safe
It
distance?
is irrelevant.
Opinion is relevant? That was it?
Did you not hear me?
I didn't.
Okay. It's irrelevant. It wasn't his command. He has answered it twice as to who you need to ask to find that out.
And coming from the first car to the second, the patrol car, okay? There was there any resistance by me?
Are you saying from sergeant vehicle to the next patrol vehicle?
No, from the moment that I was put in handcuffs against, like next to my buddy, to the moment that I was over there, where we walked over to the patrol vehicle, the first one that I was, before I got transported. Was there any signs of aggression or resistance, in your opinion,
By whom? You?
by me
Okay.
from your duties? You you recall searching me?
Yes.
Did I consent to that search?
You were detained before.
Just yes or no?
No. You can answer the question.
And your patrol vehicles, you must be searched.
Okay.
It's part of our policy, not pretty sure for Michigan law as well. So,
Okay. So at what point did I go from detained to arrested?
after Sergeant gave us the directive that you were being arrested for assault on a peace officer.
Wait. So we're on the first car. Walked over to the second car. Right? At what point I was detained all the way up until that point, and then I'm thrown in the back and I'm told I'm arrested. Did you hear that part in the video?
Yes.
So I'm just at what point? Do you know who said that in the video?
The directive.
Sergeant Gibbs?
Yes. You gave us the directive that you were being arrested for assault on a peace officer.
No. So assault wasn't mentioned until long after I was in the patrol vehicle. Okay.
So I need clarity on.
Yeah. So like right when I'm thrown in the back of the vehicle, that's the first I heard on the video of the switch from detainment to arrest. And I just wanted clarification on your perspective of that transition from detainment to arrest.
I think I'm gonna object to this asked. He's answered when he was.
Asked and answered to the extent what his opinion is may also be irrelevant.
Thank you.
He's not the one that gave the command.
Did you see me hit anybody?
No.
Did you hear any signs of stress from Officer Tyson?
Yes.
What did he do? You just said you heard signs of stress. You don't recall what they were?
Number.
Verbatim, was it words that he said? Is that what you're referring to?
He said he doesn't.
Sustained.
personally see me strike him?
Objection, asked and answered.
Sustained.
What was it? Ask. Oh, asked and answered. Could you clarify if you said that you've seen me strike anybody?
Could you what? What's the question?
Clarify if the officer's seen me strike or assault.
He's already answered that.
Um,
Well, assault's going to be another issue. But in terms of striking someone, he's already answered that.
Okay.
And I've also stated an objection from you asking it again to him. And here you go again.
all right. Is it to your knowledge that you did not suspect a crime being committed?
Can you ask your question just for clarification?
Is it to your knowledge that there, did you suspect a crime being committed by me or Jacob Spaulding
At what point?
at any point in the stop?
Can you clarify the stop?
Okay. Were you aware of Officer Tyson's statement to the Huron Valley ambulance?
Objection calls for a hearsay answer. And I don't know that it's relevant.
Sustained.
If you could define at what point the probable cause was to detain me.
You didn't listen to my sergeant's directive. So he asked you to place your hand behind your back. You did not do that. You resisted that.
When he said walk away?
No, you don't get to, excuse me, officer. You don't get to interrupt him in terms of his response. You ask the question, you let the witness answer.
Trying to get clear.
Go ahead.
And then at that point, your hands were placed behind your back. You're acting the resistance to do so. And you place handcuffs.
Okay, within 30 seconds of being on the scene.
I was not recall being there for 30 seconds.
Would you agree that alcohol was a related factor?
To what? Related factor to what?
The night, the reason why we came in contact with each other?
What's the relevance of that?
It's misreported. It's misreported in evidence. It's not there.
I'm not gonna, he doesn't have to answer that question because you've asked it in 4 or 5 different ways already.
all right.
And I'm not even sure what it means.
Do you recall what I was asking you when you were searching me?
No, no.
Do you recall a lottery ticket?
I don't recall any of the sentences you did the search.
Did you believe that Jacob Spaulding was going to get charged with a crime?
Objection, relevance.
Sustained.
No more questions, Your Honor.
I have no cross.
All right, thank you. You may step down. Thank you. Sir. So did you now wish to examine Sergeant Gibbs?
Yes.
All right. Here
Oh,
This witness, thank you, thank
You're
you.
welcome.
Yes, sir. Oh, you're good. Don't worry about it. It was a great distraction. All right. Sir, if you could please come forward and be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony?
Martez Gibbs, Martezgibbs.
You may inquire.
Good afternoon. State your badge number for the record, please.
366.
266. Okay. You recall the events of October 11th.
Yes.
Have you had a chance to review any of the videos?
Yes.
I'm not going to bore us anymore. I'm going to really try to get to the point here. What was your, if you could articulate the probable cause as to my arrest?
To your arrest? Well, Arnold and assault to an officer.
Okay. All right. RNO was the initial one, correct?
Yes.
Okay. So, at what point did you determine that I was resisting or obstructing? Is that correct? Is that the
Resisting obstruction. It'll be when told to put your hands behind your back, you tensed up, start to pull away, which other officers had to come and help me get cuffs on you, took you over to the vehicle, held you against the vehicle to put you in handcuffs, at which point.
Okay. Well, there's a lot of events, so I'm going to just try to keep it at the one right now. Thank you. So it was, you said the point I was being detained was, or I'm sorry, resisting for.
Yes. So you're talking about detainment or arrest. So we got two different things going on.
Okay. So let's walk me through it. I was detained for.
You were detained for interfering.
Okay. Interfering. What was I interfering?
You were interfering with my investigation, trying to help your friend who was extremely intoxicated. Yes.
Okay. Trying to help my friend. Is that your lawful duty?
Yes.
To help my friend?
Yes, to help. Yes.
Okay. Okay, you were. You said a couple parts. Go back to the detainment. So it was for interfering.
Yes.
Okay. Did I verbally interfere?
Yes.
Did I physically interfere?
You kept getting closer to your friend, so that would be physically interfering.
Physically interfering. Okay. For your investigation against
Yes.
my friend.
Yes.
Did you assume he was doing anything unlawful?
No, he wasn't doing anything unlawful.
Okay. You just want to help out, which was
Exactly. He was highly intoxicated.
okay. Do you recall me asking you anything when you first showed up on the scene?
I'm sorry. Say one more. I'm sorry.
Do you recall any questions that I had for you when you guys showed up on the scene?
Judge's hearsay.
Sustained.
Hearsay. If you could give me your timeline, I mean, I could play the video, but give me your idea. How long was it from the point you showed up on the scene and then I was arrested? Or I'm sorry, detained.
Say maybe possibly 5 minutes or so.
5 minutes? If I told you it was under 40 seconds, would you believe me?
But you want to know that I would take your word for it.
Okay.
Sure.
All right. Do you assume that I was at that time when you showed up? Did you assume that I was up to a fight that you were dispatched for? Or did you clarify that that was something?
No, I.
You knew I wasn't in a fight. Okay. So, so basically what I have here really is, I've watched the video thousands of times, right? I get me and you at a disagreement, right? In your words, what would be the disagreement?
You weren't fair. I'm trying to help your friend. You're telling me I have him, I got him. Well, that didn't seem to be the case. If you had him, he wouldn't have been on ground drunk. So therefore, it's my duty as a peace officer to ensure that this man is safe. And
because I wasn't doing
it. You were not.
That's what you're, okay. Who ordered the HVA ambulance for?
Objection, relevance.
Stan, what's the relevance of that?
Good question.
I know.
All right.
Well, if you don't have an answer, objection sustained.
If you watch the video, sir, I gave the order for them to call HVA.
Thank you. Speaking my language now. All right. Did I make you feel threatened in any way?
Did you make me feel threatened in any way? No, sir.
No. I didn't give you an aggressive vibe or anything?
You gave me the aggressive vibe when you tensed up, but initially, oh.
Okay. What did you tell me before detaining me?
I told you to walk away several times.
Walk away.
Yes, to walk away.
That's a, would you call that or consider it a lawful command?
That was definitely a lawful order, yes.
Okay. Do you know under what law that would be?
I cannot say that off the top of my head, I'm sorry.
Okay.
It is definitely a lawful command. You're interfering. I asked several times.
You know if it says like a certain distance?
If what says a certain distance?
The regulation on the lawful command.
What regulation are you talking about?
My safe distance from my public
Okay.
private space.
Mr. Magoo, that's going to depend upon context.
Right.
It depends on what they're investigating. So what are you asking?
Right. At what distance would have been safe?
You could walk to the sidewalk. You just stay there. That's it. That's all I want. You didn't have to leave.
Man, that would have been so easy. That would have been so easy, right?
Oh, yeah.
Mm-hmm. Still.
Sergeant Gibbs takes the stand and the defendant goes straight for the throat. He asks Gibbs to justify the probable cause for his arrest, walking through each moment step by step. Gibbs explains the detainment began when the defendant refused to walk away from an intoxicated friend during a welfare check. The defendant presses hard, noting he never physically touched anyone, never threatened anyone, and never prevented the officers from doing their job. Gibbs admits the friend was not committing a crime. Then comes a striking moment when Gibbs tells the defendant simply walking to the sidewalk would have been enough to avoid the entire arrest. The defendant visibly reacts.
Trying to figure out this time though. I was first, right? There was no investigation. So at what point does investigating somebody else's drunkenness determine my arrest?
When I'm trying to assess a gentleman who's high intox and you're interfering with that, that's when that justifies that.
You're interfering with your, would you call it a civil act of checking on his welfare?
Oh,
Yes?
go ahead. You go ahead and answer.
Okay. So still no crime.
No,
You were just helping out.
It's
I,
not illegal to be drunk in public.
Right.
Drunk and disorderly as you were. That's the problem.
okay. I was disorderly.
Yes, you were definitely disorderly.
Okay. I was disordering your investigation into the civil matter related to someone else.
Oh, I'm sorry. Say that one more time.
You said I was disorderly.
Yes, you were drunk.
So in the process, I was, because it's under 40 seconds, right?
Okay.
So within 40 seconds, I didn't listen to your walk away command when you're trying to investigate someone else's intoxicity and welfare. God bless you.
Objection is to form of the question.
It's a form of question. Knowing that there was no crime, would you agree that?
Or your friend?
Showing up on the scene, you guys were trying to get information about
A fight, an alleged fight.
a fight. Okay,
Once we saw there was no fight.
right, and it wasn't that.
Your friend.
Right, drunk guy.
Yes.
Right.
The guy intoxicated.
Let's take care of him.
Exactly.
Okay, so you're trying to take care of him,
Yes.
and what did you think I was doing?
Objection is to speculation.
Over.
Did I?
Let's hear.
What I think you were doing,
Yeah.
hindering, being obnoxious. With
Okay. If
Wow.
you never showed up, what do you think would have happened?
Objection is speculation.
Sustained.
I just have a picture, Your Honor.
Of what?
Just the night in question, just a picture
I
of,
would really like to see any exhibits
Just-
before you show them to the court.
there you go. Just me.
Do you have a copy for me?
You can have that one.
Great.
Can I show them real quick? I just-
What?
Yeah, I'll give it to you.
No,
George.
What's it a picture of? And for what purpose am I seeing this picture?
Identification
Of who?
of me, what was going on before. These.
A picture's gonna tell me all that? You got a picture and a picture.
well, there's no other copy, Your Honor, so.
No, that's
I
fine.
would have sent it to you digitally, I got. I mean, can I do it? No. Come on,
So what do you
man
want?
here.
Are you gonna introduce that picture as evidence of something or try to?
Oh, I just, yeah, I'm gonna try to.
You're gonna try to. All right, let's have it marked. Defendant's Exhibit A.
It's just identification purposes, really. I see a confused look on your face. Before you guys arrived on the
Confused look.
scene. What was that?
What are you talking about? Who's confused? Look.
Oh, no, but it was, I
Oh,
was just,
trust me. I think
Everyone.
the sergeant knows more about identification of an object in court than you ever possibly will. So
Right.
I don't think he was confused at all,
oh, okay, yeah.
but appreciate your concern. Can we get that marked so we can get this done?
It is marked down.
Thank you. I'm sorry, Ann. I didn't mean to rush you, but sooner or later we gotta go home.
Yeah,
Okay. Witness has been marked as Defendant's Exhibit A. Do you have a question, Harry?
do you recognize those two gentlemen?
Yes, sir.
Okay. If you could give your opinion of the two,
Objection, foundation.
sorry,
Sustained.
to what we're wearing, look familiar, that was the same night, would you agree?
Objection, foundation.
Sustained.
Foundation. Um, I'm still trying to get to a crime that I committed, and this is before you showed up. This is, I was waiting on a ride, right?
Hold on a second. So the photo that you're showing is an.
It's just thrown out.
No, quit interrupting me. The photo, Defense Exhibit A, is a picture of events you know are prior to the sergeant getting there.
Right.
Then how's he going to answer any questions about it?
Like I said, it was for identifications at first.
Of what?
Of the condition.
You've already
of
been
which-
identified.
The condition of us. I was the one, and I was. Yeah, but like I said, I know what happened. That
Okay,
night,
that's fine.
but I'm trying to prove it, and yeah, please,
Prove,
just
what are you trying to prove?
that there was no crime.
That picture doesn't do it. I'm not
The night
going to
before
accept the picture. You
Ypsilanti-
can't lay a foundation for that photo.
You're right.
I know
That
that.
was for identification, like I said, so we can just get rid of it.
So Defense Exhibit A is not admitted. All right, go on to the next thing, please.
Okay.
Yeah, he gives that back to us. Thank you, Alan.
Thank you. Do you recall the presence of alcohol on the scene?
Yes, sir.
Do you recall reporting that there was alcohol on the scene?
Yes.
You did report it?
Yes.
Um,
It says it in the report.
Says it in the report?
Yes.
Okay. Would you consider it to be a significant factor of the night?
Objection.
Which night? Yeah, I'll
You know,
sustain the objection.
it's-
You need to ask better questions.
Yeah. This is last question. Could you just clarify your duties overall that night in regards to me and my arrest?
Clarify my duties in regards to your arrest.
The probable cause for my arrest. Could you establish the probable cause that you RNO for not listening to the walk away command? Okay. The walk away command is what you're referring to though, right? For the probable cause.
The walkway was your detained. I detained you because you did not walk away.
Okay.
And had you just put the cuffs on smoothly, it would have been fine. You cuff you, when you resist, you tense up, you pull away, that starts the RNO. Then when you strike an officer with your foot, that further strikes that RNO as well. So therefore, you got assault to an officer, you activate your RNO. So that's why you were arrested, sir.
Okay. Did you physically see me assault anybody?
No, I was over there dealing with your highly inebriated friend.
Okay. No more questions, Your Honor. Thank you, Officer. Sergeant.
I have no cross-examination.
I was hoping that was true. You may step down, Sergeant. Thank you. Any other witnesses for the defense?
No witnesses.
Any rebuttal witnesses for the people?
No, Your Honor.
Do you have a motion?
I do. To find over on count one, next charge, assaulting, resisting, or obstructing Officer Darnell Tyson, reserve any further argument for rebuttal.
Response.
Your Honor, I, under MCR 6110F, dismissal, lack of probable cause and insufficient evidence. There's no proof of any harm done. The officer that said I struck him, you know, he also said that I didn't, and he was just kidding. We all heard it, didn't want to play it over again for some reason, but it was pretty clear what he said. And I appreciate the officer showing up to assist my friend with a highly intoxicated cause for investigation, but I do that does not warrant my detainment, much less my arrest. Yeah, and under MCR 6110F, dismissal lack of a probable cause, there was no probable cause. Anything after that is thrown out and inadmissible. It's under Matt versus Ohio.
Ms. Lundy, any response?
No, Your Honor.
Thank you. I don't really need it. Folks, give me 5 minutes. I'll come back with my decision on this. I
Police officers have been here since before now.
oh no, they're gonna be here as long as I am. No, they cannot go anywhere. What'd you say? I don't think that's what he said, but that's all right. We're staying in recess.
All right. Maybe see. All right. 14A District Court for County of Washington, State of Michigan is back in session. The Honorable Judge Jason.
Thank you. You may be seated. All right. Having no additional argument in this case, the facts and circumstances of this case, the people with reference to count one, the charges as against Officer Tyson, the people have sustained their burden of showing that the offense of resisting and obstructing that officer, Officer Tyson, was done by the defendant on that date and at that time. Additionally, as the court can do pursuant to court rule and statute, court does believe that other offenses were committed during the course of this, which are 2 other additional charges of resisting and obstructing, specifically when starting, I guess, with what it will make count 2, with regard to Sergeant Gibbs, the failure to follow the sergeant's command, and I have to give the sergeant all the credit in the world that he gave continuous warnings for the defendant to remove himself from the area. The defendant then refused to do so. At the point at which also the defendant is being detained and put into handcuffs, there is sufficient testimony that at that point the defendant committed a separate offense of obstruction at that point in resisting the officers, and then ultimately the one to the kick to the groin of Officer Tyson. So those in essence constitute the 3 separate counts of resisting and obstructing. Therefore, the defendant is bound over to circuit court on those 3 charges.
Your Honor, can I ask a clarifying question so I make sure
Certainly.
I file a corrected amended information? The court found probable cause for added count 3 and resisting, obstructing, opposing, or endangering which officers? All 3?
Yes, all 3 officers. So count 1 is referenced Officer Tyson. Count 2 is referencing Sergeant Gibbs. Count 3 is referencing Officer Smith. With regard to taking the defendant into custody and his resisting of the handcuffing, as well as, quite frankly, his resisting of, during the pat down, the refusal to acknowledge or respond to the officer's questions can constitute obstruction. So he is bound over on those 3 charges. Do you understand that, Mr. Magoo?
Still argue probable cause, but I'll let the paperwork from this point forward talk. Your Honor.
Pardon? What are you saying?
No questions over there.
All right. Do you wish to have the information presented to you and then arraigned on that information?
No.
All right, so you're waiving presentation and reading of that information?
Sure.
All right. Defendant having waived presentation and reading of the information. And sir, what plea are you entering to those 3 counts?
I'm innocent, Your Honor.
Okay. Here are your choices. You can plead not guilty, you can plead guilty, or you can stand mute, say nothing, and the court will enter a not guilty plea for you. Out those 3 options, How would you like to plead to the three charges?
Same you.
Defendant having waived formal reading, standing mute to all three counts. Court will enter a not guilty plea as to all three counts. Pre-trial in this matter will be set for
April 3rd at 1:30 p.m. with Judge Slay.
April 3rd, 2025, 1:30 before Judge Slay.
May I have until noon tomorrow to submit a signed amended information to?
Yes, we'll hold the file.
Thank
If you if you do that, that way the whole file can go up.
My goal will be by noon tomorrow.
Fantastic.
Previously, the defendant has accepted email service of motions, but the court be so kind as to make inquiries if he'll accept email service of the signed information.
Sir,
Emails, I can,
there'll be an information which is very similar to the complaint in this case. It will be signed off by the prosecutor based upon the court's rule. What the prosecutor is asking is, will you receive an email and take that as service of your copy of the information?
yes, Your Honor.
All right. Thank you. Great. Bond will continue. Thank you.
The hearing reaches its conclusion. After both sides rest, the judge takes a brief recess and returns with a decisive ruling. He finds probable cause on not one but three separate counts of resisting and obstructing, covering Officer Tyson, Sergeant Gibbs, and Officer Smith. The defendant, who represented himself throughout, quietly disputes the finding but chooses to stand mute rather than enter a formal plea. The court enters not guilty on all three counts, and a pretrial date is set for April 3rd. The defendant fought hard, raised sharp questions, but is now heading to circuit court facing 3 charges. Like the video, subscribe to the channel, and we'll see you in the next video.